Hi, I'm Ron Miller. Today I want to talk to you about the assumption of risk defense. Personal injury law in Maryland and in Washington, D.C. allows a negligent defendant to raise affirmative defenses to escape liability, even when they're dead bang responsible. The most common affirmative defenses our lawyers see is contributory negligence. We have a separate video on this defense, and we have a link to it at the end of the video if you want to watch that one. Another affirmative defense used by negligent defendants is an assumption of the risk, which is certainly a close cousin of contributory negligence. Assumption of the risk is a big deal because it bars the plaintiff's claim regardless of how awful the defendant's negligent conduct was. In Schroyer versus McNeal, the Maryland Court of Appeals defined assumption of the risk by saying a plaintiff is completely barred from recovery if he or she assumes the risk of injury when, with full knowledge and understanding of an obvious danger, he or she voluntarily exposes himself or herself to that risk of injury. Let's break that down. There are 3 requirements that a defendant must prove to establish a defense of assumption of the risk. 1, the plaintiff had knowledge of the risk of the danger. 2, the plaintiff appreciated that risk. And 3, the plaintiff voluntarily confronted the risk of danger. All these rules have case laws been flushed out in Maryland to really make things harder for the plaintiff. For the knowledge and appreciation of the risk, Maryland, unlike a lot of states, including Virginia, uses an objective standard for what's an obvious risk. So if the plaintiff says, hey, I didn't understand the risk, a judge could say, well, you should have, and dismiss the case long before it ever gets to a jury. As for voluntariness, Maryland does not even make exceptions for employees. About 25 years ago, there was a case. It was Martin versus the ADM Partnership. You can find this site in the notes on this video. There's a delivery guy who was delivering blueprints across the snow. He had to walk across snow because he wanted to keep his job, and that's what his job required him to do. The court said, as a matter of law, he had assumed the risk. I mean, it really is a ridiculous law that we'll someday get rid of, but not today, unfortunately. What is the difference between assumption of the risk and contributory negligence? There's not much difference between the two, but assumption of the risk implies intentional exposure to a known danger, something that may or may not be true of contributory negligence. Also, contributory negligence has the same elements of regular negligence, but the elements of negligence don't need to be proven in assumption of risk. So those are my thoughts on assumption of risk. You can get more information on assumption of risk on our website, which will be in the notes of this video and within the notes on the video themselves. If you came here hoping to get a better understanding of how the assumption of risk works, I hope this video is helpful for you. If you have a question, please leave it in the comments. We check them pretty regularly. And don't forget to subscribe to our channel to get more information on Miller & Zoyce. You can click on this subscribe button right here. And thanks for watching.